Yes, thank you, Shubha. So, good morning, all of you. It's my honor and pleasure to welcome at this point. We are really proud to have you all for the program on mainly the what, why, and how of patents. The Institution Innovation Council of Sri Nehru Mahavidyalaya College of Arts and Science is proudly organizing this program mainly for the faculty and even the research scholars, PG students. So at this juncture, it's my honor and pleasure to welcome the chief guest, Ms. Latika Kanduja, founder and director of IPLOEA, patent agent, Gurugram, India. Welcome me, ma'am. And it's my honor to welcome our dynamic leader and our mentor, our beloved principal, Dr. B. Subramani. He's the president of our IIC, SNMV CAS. Welcome you, sir. And it's my duty to welcome the organizer, the convener of IIC of SNMV CAS, Mrs. Selva Jayanti. Welcome you, ma'am. And I'm very much pleasure. Without you people, it's not possible to have all the programs. You're all behind the success of every each programs happening in the campus. Beloved faculty members and student friends, and welcome you all once again. Thank you so much.
Yes, thank you so much for the opportunity given to me. Being placement officer for the college, it's my privilege to introduce the guest for this gathering. Ms. Latika Ganduja, founder of IP Solutions Firm, IPLOEA. To start with the academics, she's from engineering background with a specialization in electronics and instrumentation from NCU, the North Cap University, and registered Indian patent agent 3537 LLB CCS University. She has worked on technologies ranging from electronics, telecom, electrical, mechanical, automotive, home appliances, semiconductors to medical imaging. She is the founder and director of IPLOEA with a decade of experience. Her company supports startups and SMEs in planning their IP strategy, protecting innovation, managing IP assets, and providing support during IP litigations. Being the founder, she is responsible for all the activities and initiatives taken in the company. Starting from clients reaching out, marketing, solutioning, to handling operations tasks like project scoping, quality checks, employee management, ensuring customer satisfaction. Everything is handled by Ms. Latika Kanduja. Our team have got a single focus to provide the same experience and quality on every project to their customer as is delivered on a pilot project. Her focus on quality does not get wavered, whether she is working with the customer for the first time or have been working with the same customer for many years. In addition, no report goes to the customer without a sign. So such an eminent person is here with us, and there is a lot more information to share with her that goes a lot of pages. So we have cut short it out and we have given the special points that has to be given to the students and the participants. Thank you so much for the opportunity, ma'am. I welcome you for the session.
Thank you so much, sir, for introducing me and for giving me this opportunity to connect with all of you today. I welcome you all in today's webinar. So without any further delay, let me share my screen. So ma'am, can I share it or do you want me to wait?
You can share, ma'am.
Okay, thank you. Let me share my screen. I hope my screen is visible.
Yes, ma'am.
Still loading. Okay. Okay. So today we are going to discuss about various intellectual property rights. So that includes what are patents, what we have to do whenever we have any idea, what is the process of getting a patent and timelines for that, and how we can help you at each and every stage, and how patents are different from other IPR forms. So for example, how patents are different from design registration, how patents are different from copyright, trademark, so on. Before I actually start the main part of the presentation, I would like to take 2 minutes of your time to talk about a very interesting man. That's Dr. Michael Doyle. I believe that most of you are not aware of this person, and that is why I'm taking this opportunity to talk about him. So who was he? He was an inventor or researcher like you and me in University of California. And he invented a web browser that supported plugins, streaming media, and cloud computing. And he was intelligent enough, and he was aware of importance of patents. That is why he protected his innovation by means of patents, by filing patent application in 1990s. And you know what happened next? He found that Microsoft, which is one of the biggest companies in the world, is using his patent protected technology in Internet Explorer. And that is why, and not only Microsoft, there were other companies too who were using his patent protected technology. That is why Michael Doyle reached to Microsoft for licensing, but of course Microsoft denied. And that is why Michael Doyle reached to US court and filed suit against Microsoft. And in return, he was awarded damages of $521 million. That's the power of patents. So as you can understand that he could have simply worked on his technology to make sure that it has more and more features, it is user-friendly and so on. But since he was aware of importance of patents and he actually took out time for this, that is why he earned such a huge amount of money. I mean, he might not have earned such a huge amount of money just by working on his idea, right? So, next, Michael Doyle could be you, but only and only if you protect your idea today. Because if you do not protect your idea today, then you might regret in future that since you did not protect at that point of time, you just lost the opportunity because now somebody else has already published it, right? So now let's start with the main part of the presentation to see what are patents and what all about it. Okay, so patent, as you might be aware, that it's a legal right that is given to a person over creation of his or her mind, and it is mainly used to prevent others from making, using, offering for sale, selling, or importing the invention. So let me explain this in a very simple manner. So whenever you build a house, what do? You actually try to create a boundary around your house to say that, okay, inside this boundary, this is my property. This is my house. I have the right on it. If you want to use it, then either take permission from me or give me rent, right? Similarly, patents are also used to create boundary around your innovation. To say that inside this boundary, this is my property. I have the right on it. If you want to use it, then either take permission from me or maybe give royalty in return, right? So patents mainly is used to protect functionality. Okay, there are various types of IPs, but patent is mainly used to protect functionality of your innovation. Let's understand it through some examples. So you can think of a recommendation engine that recommends similar products to a user. Okay, that can be on the basis of anything, maybe age of the user, location of the user, search history of the user, and so on. You can also think of a recommendation engine that recommends a specific route in going from one position to another. Okay, think of a social media platform that provides ads based on user profile. Think of autonomous vehicles. That's so much in news nowadays. Web camera, features of the application running on your phone, measuring tool. These are some of the examples of which can be patented or which are already being patented. Okay. So in order to get a patent, there are broadly two criterias. Okay. First is that it should be new worldwide. So that means it should not be disclosed anywhere else in the world. Okay. Secondly, it should not be obvious to the examiner. So it should not happen that from one application we are taking out one feature, and from another application we are taking out another feature, and we are simply aggregating the two without any inventive step. So that is not patentable. Okay. So broadly, in India, if let's say your idea is new, but it is not obvious, still there are certain categories on which you still cannot obtain a patent. Okay, so let me take you through that. Although the list is not comprehensive, but I would like to just give overview of it. Okay, so any invention that is frivolous in nature or that is against natural laws cannot be patented. Okay. Inventions that are contrary to morality, so that means it can be harmful to any human beings or animals, cannot be patented. Mere discovery of a scientific principle and mere discovery of living and non-living thing per se cannot be patented. Okay. Method for doing the agriculture or horticulture cannot be patented. However, if you are coming up with a new a new tool, new device, new instrument for doing the agriculture or horticulture, that can certainly be patented, but not the method for this. Okay. Let's see some more categories around it. So new form, property, use of a known substance cannot be patented. Okay. So for example, if we are coming up with the fact that turmeric can be used to treat coronavirus, okay, that cannot be patented because turmeric is a known substance and you're just coming up with a new use of it, so it cannot be patented. Okay. Similarly, mere admixture, mere rearrangement of devices, plants and animals per se, process of therapeutic treatment are some of the categories on which you cannot obtain a patent. Okay, I hope this is clear. Now, moving on to discuss the very important topic of the day. Because if we are not clear with this, of course, we will not protect our ideas. So why do we need to register a patent? So first is that, to stop anyone from copying your idea. Of course, that's your invention. You have put such a hard work on it. Why do you want others to steal just like that? Right? So that is why patents are used. Another reason for filing a patent application is that it acts as a source of revenue. So we have seen in case of Dr. Michael Doyle that how much money he has earned because of because other companies were using his patent protected technology. Similarly, you can also think of it as a source of revenue. If you want to license it or you actually found that somebody is using your protected technology. Another reason for registering a patent is to gain marketing edge and credibility. So that is, to gain trust of the customer. So you might have seen in case of various FMCG products that they actually write patent number, or they actually use the tag patent pending on their product. So why they do so? Have you ever thought about it? So it is mainly to get trust of the customer. So let's say if the customer is going out for a shopping and he can see that there are various products lying on the shelf, and in one of the products, patent number is mentioned. So you might think that since they have already got a patent on this, so the technology is of course new, and that is why the quality of this product might be better than rest of the products, right? So that is how it is used to gain trust of the customer. Another reason to register a patent is to increase valuation of your company. So I was in discussion with lots and lots of startups, and one of the main reasons why they want to file a patent application is to increase valuation of their company. So it may be up to 2 times, 3 times, 10 times, depending upon lots of factors. And in fact, whenever they reach out to any investors for funding, so they also ask this question, whether your idea is patent protected or not. Because everybody wants to, investors also want to invest in a company whose idea is protected so that nobody can enter their domain easily, right? So these are some of the advantages to register a patent. It is not that, the advantages are limited to these 4, but these are the top most important advantages. And that is why I discuss those. Okay, great. So let's move on to understand, whenever you have any idea, what you have to do, okay? Whenever you have an idea, please reach out to an expert patent firm like me for guidance, and ensure that you do not disclose your idea in public domain. So that means it should not be disclosed on any of the website. It should not be disclosed on any social media platform or anywhere else, because in that case, your own publication will become your own prior art. Okay. And whenever you reach out to expert patent firm, please make sure that you sign an NDA with them, because it's your invention, right? So you want to protect it. And very importantly, you have to decide in which countries you want to patent your idea. So, patents are territorial. So that means, let's say if you want to protect your idea in India, we have to file the patent application in Indian Patent Office. Okay. But let's say if you want to protect your idea in US as well, then we have to file the patent application at US Patent Office as well. Okay. So it is not that you file a patent in India and you get worldwide coverage. So it doesn't work like that. Okay, great. Let's move on. So whenever you reach out to any patent firm, what they generally propose as next steps. So first, they will assist in checking whether the idea is patentable or not. So that means they will assist in checking, whether the idea is already, similar idea has been disclosed in the public domain or not prior to this. Okay. So whether this is unique or not, in short. And based on that, they will assist in applying for a provisional or a non-provisional patent application. So let me discuss the provisional and non-provisional in detail with you. So as the name suggests, provisional application is a preliminary application that may be filed when your invention is still evolving. So that means you have got the basic idea, but you still need some time to complete it. You still need time to add more value to it. So in this particular case, you may want to protect your basic idea first and then work on completing it. Because let's say during, if you wait for the complete idea to be completed or done, then in that case, any other person may just publish the idea, right? So that is why, whenever you have any basic idea, please do not wait to complete it. Just file the provisional application and then start working on it to complete it. Okay. There's a specific time in which you have to file the regular or non-provisional patent application once you file the provisional application. Okay, and this is completely optional. If your idea is complete, then you do not need any provisional application. You can directly start with the non-provisional application. Okay. Now let me take you to the non-provisional application. So as I mentioned that these are the formal or regular patent applications which we need to file within 12 months. So let's say if you start with the provisional application today, you will get 12 months of time to file the non-provisional application corresponding to that. Okay, you cannot miss this even by one day, because if you do that, if the 12 months timeline has passed, then in that case your provisional application will be abandoned and you cannot do anything. Okay, and that is why we generally advise that if your idea is complete, you directly start with the non-provisional application, because of course it will expedite few things as well. Okay, great. So with that, let's take a quick break here and see how much we understood. So if I file a patent in India, I get worldwide protection for my invention. Very easy, I would say. Option number 1 true, option number 2 false. Kindly share your answers through chat box, and even though it is wrong, please feel free to share your answers with me. Thank you for sharing your answers. And yes, you're right. Option number 2 false is the right answer. So if I file a patent in India, I get protection only in India. But if I, let's say, want protection in other countries as well, we have to file patent application in other countries as well. Great. So let's move on to discuss what is the process of obtaining a patent. So we'll start with step number 1, which is optional but highly recommended. So in this case, we conduct a search to check whether your idea is unique or not. Okay, before actually going forward. So we check at the first place whether your idea is new or not. So in this case, let's say if somebody sitting in US has published your idea in public domain, or in the research paper, then we cannot get a patent in India as well. Okay, so that is why this we conduct this step at step 1. After this, the process moves to step number 2, where we have to draft the patent application and file it at patent office. So a patent is a techno-legal document. So it is a very lengthy document, like 20 to 30 page document minimum. And in this, we have to describe all the details about your invention. Okay. So for example, if you're coming up with a new product, then we need to mention what all components it will have, and after that, how they are working, how they are connected to each other, how it is different from other products in the market, and so on and so forth. Okay, so you even you can also draft a patent application by your own. However, of course, you have the technical expertise to draft the patent application, but you might not have the legal expertise to draft it, and that is why the boundary that you will create around your innovation would be narrow, and because of this, the commercial value of the patent will go down, and that is why it is highly recommended to hire a patent agent or attorney like me for drafting a good patent application for you. So once it is drafted, we have to file it at patent office wherever you want to protect your invention. After this, the process moves to step number 3. So in this case, once a patent is filed, it will be published after 18 months in general. Okay, that's the general process. But if you want to expedite any of the processes, please let me know. There are provisions for that, and we can expedite any of the process. So for example, we can expedite the publication as well, and once it is expedited, instead of 18 months, it will be published in a month. Okay, so there are provisions, I'm saying. Once your patent is published, so that means it is there in the public domain, then it will enter the queue for examination. So in this step number 4, examiner would look at your patent application to see whether your idea is unique or not, whether your idea is obvious or not, whether your idea is clear or not. And based on these parameters and other parameters, he will generate his examination report, and we need to respond to the comments mentioned in the examination report. There could be hearings as well, but you don't have to worry because we will take care of everything. Okay, so if the examiner is convinced that yes, your idea is new and it is not obvious, then he will grant the patent to you. However, if he believes that your idea is not unique, he can also refuse the patent application as well. Okay, I hope this is clear. Now let me take you through the timelines of this. So it is just the summary of what we have discussed so far. So let's say if you start with the provisional application today, you have got 12 months to file the non-provisional or regular patent application. You cannot miss even by 1 day, because if you do that, your provisional application will be abandoned. Okay, and filing the provisional is completely optional. You can directly start with the non-provisional one. Okay. Once the non-provisional is filed, it will be published, or that means it will come in the public domain after 18 months in a standard route or normal route. But if you want to expedite any of the process, please let me know. Okay. Once your patent application is published, then it will enter the queue for examination, and in this phase, examiner would examine your patent application, and if he believes that your idea is unique and it is not obvious, he will grant the patent to you. And in general, in the normal route, you can say that on an average it is like 2 to 5 years from the date of filing the non-provisional application, right? So this actually depends upon lots of factors, so which are not really under our control as well. So for example, backlog of patent office and so on and so forth. Okay. So once a patent is granted, it is valid for 20 years from the date of filing. After that, your patent will expire. You cannot renew it. Anyone can use it freely. So you will get basically rights for 20 years from the filing date. Okay. So I hope this is clear. With that, let's take a quick break again and see how much we understood. Once granted, the patent gives you on your right, gives you right on your invention for option number 1, 20 years from the filing date. Option number 2, 20 years from the grant date. Option number 3, 10 years from the filing date. Option number 4, lifetime of the inventor. Kindly share your answers, even though it is wrong. Thank you for sharing your answers. So the correct answer is option number 1. That is 20 years from the filing date. So, there are various intellectual properties. They have different timelines. So, first is, patents. Patents have different validity. Design have different validity. Copyright have different validity. So, but for patents, it is actually 20 years from the filing date. Although you will get the rights when the patent is granted, but when the patent is granted, it will give you the right for 20 years from the filing date. Okay, I hope you have understood this point. Now, moving on to discuss how we can help you in getting a patent, and after that also. So first of all, we'll be providing free of cost ideation and innovation consultancy to you. So let's say if you have got the broad idea, but you're not sure how to go about it, please let us know. We're there to help you. Let's say if you're coming up with a product and you're not sure what all features, you need to protect, then, we will dig down into the details of your product to, find out all the potential features that can be patented. Okay. After that, we will provide support in conducting patentability search. In this, we will determine whether the idea similar to yours has already been disclosed or not. So we use our paid databases to check, similar ideas in whether they are patented or disclosed. After that, we will provide support in drafting good quality patent applications for you and file it at various patent office wherever you want to protect. So let's say if you want to protect only in India, we will file in India. If you want to protect your innovation in, let's say, US as well, then we will file it at US as well. Okay. After this, our support doesn't stop there. We will also support in the patent examination as well. Okay. And we'll take care of all the responses. We'll take care of all the hearings and until you get a patent granted. And in some part of it, we will also provide support in patent commercialization as well. Okay. I hope this is clear. So this was all about patents. Now let me talk about other forms of IPRs. Okay. So so this is just a brief overview. I will talk about in detail in subsequent slides. So patents, as we have covered, it is mainly used to protect functionality of your idea. Okay. Design is mainly used to protect design of your 3D work. Copyright is to protect creativity of your work, and trademark is used to protect brand of your company. Okay. So now let me discuss in detail. So patents I have already covered. So this for design actually protects outer appearance or ornamental features of a product. Okay. And it is again used for the same thing to prevent others from making, using, offering for sale, selling, or importing the product. Okay. So whenever you see any new car in the market, so the design of that car might already be protected before they actually launched it, because of course they want to protect the shape so that nobody else can copy it and launch it again, right? So that is why design registration comes into picture. Let's see some more examples around it. So you might already be using Apple iPhone, or you might have seen that. So Apple have protected a lot of their features. So for example, Apple have protected their design of having a circular home button at the downside, okay? So that no other company like Samsung, Oppo, or any other company cannot have this kind of design in their phones, because this is already protected by Apple, okay? Similarly, Apple have also protected their design of Apple Watch so that nobody can, use it or copy it. Okay. Now, moving on to the next form of IPR, that is copyright. So, copyright is mainly used to protect authors' original work. So, for example, any creativity, like if you have written any book, any poem, plays, songs, films, artwork. So all these things would be protected by means of copyright. And again, it is used to stop others from using or copying your the author's work. Okay. So let's see some examples. So as I mentioned that if you have written any book, you have made any painting, you have written any lyrics of the song, you have made any cartoon, photography. So all these things are protected by means of copyright. So I believe that you might be having confusion between patents and copyright. So let me try to explain one example. I'll use the same example of recommending similar products to a user. Okay, in Amazon, you might have seen that. So in this particular case, of course, you will write some algorithm, the codes, so that it can give the recommendation. So the algorithm per se would not be protected by means of patents, but it would be protected by means of copyright. Okay. And I would say that, the scope of protection of patent is much broader as opposed to copyright. Why? Because as you can understand that, in copyright, you are just protecting the algorithm. So that means, any other person can just manipulate the codes, but he can still use the same parameters, same conditions and everything to generate the same output, right? However, if your idea is protected, in that case, he cannot create algorithm for, using the same parameters to give the same output, because the idea itself is protected. So he cannot create algorithm B or algorithm C to give the same result based on the same parameters, right? I hope this is clear. Now let me take you through the last form of IPR, that is trademark. So, what is a trademark? So you might be actually looking at hundreds of trademarks per day, but you might not be realizing it. So trademark is a sign, logo, tagline, expression that distinguishes goods and services of one company from goods and services of another company. And it is again used to protect brand of a company. Okay. So for example, this is a trademark of Coca-Cola, and this is a trademark of Pepsi. So what is it is used for? It is used to distinguish the soft drinks made by Coca-Cola from the soft drinks prepared by Pepsi, right? So that means, Coca-Cola cannot start manufacturing and selling Pepsi under their name, and vice versa. And whenever they have to go for advertisement or anything, they can do that by means of their trademarks, right? So broadly, you can say that it is mainly used to protect brand of a company. So before I actually move on, I would like to say that whenever you have any idea, so you have to see what all IPs do you need. It is not that you only need patents, or you only need design, or you only need trademark or copyright. So you have to see what all kind of protection you want for your product. So for example, if you're coming up with a so would you please put yourself on mute? Gopal sir. Thank you. So let's say if you are coming up with an automatic machine, okay, automatic machine that can clean the floors, which can also clean the corners as well. So in that case, you might need patents, because in order to protect their functionality, because it's an automatic machine, right? Secondly, since it is able to clean the corners as well, so the design is also new. So you might want to go for design registration as well. Okay. Thirdly, you might want to give a name to your product. So the name would be protected by means of trademark. Okay. So whenever you have any idea, please see that, what all kind of IPs are relevant for you. And based on that, you have to work. So these are, what we have discussed today. They are some form of IP. So it is not that these are the only forms of IPs. So there are other forms of IPs, but then these are the most commonly used intellectual properties. Okay. So if, let's say, you want to know more about others, you may reach out to me directly, and I'll be happy to help you. Okay. So with that, let's take a quick break again. How can I protect the tagline of my product? Option number 1, by filing for a patent. Option number 2, by filing for a trademark. Option number 3, by filing for a copyright. Option number 4, by registering a design. Please share your answers. Thank you for sharing your answers. And yes, again, you all are right. The correct answer is option number 2, by filing for a trademark. Yes, that's correct. Great, great. Thank you for sharing your answers. And with that, I would like to thank you all for joining today's webinar. I hope you have found it useful. If you want to know more about patents and other IPR forms, please follow IP Loya on LinkedIn, because we usually post on patents and other forms of IPRs. And you can also visit us at www.iploya.com. Or in case of any queries, you may reach out to me at latika.kanuja@iploya.com or at info@iploya.com. In case of any queries, you can also call me directly at 9811 I'll assist you wherever I can. So with that, we can now switch to Q&A sessions. So whatever queries you have, you can ask. And let's say if due to lack of time I'm unable to resolve your queries, please feel free to reach out to me directly, and I'll help you with that. Thank you so much. Now we can move to question and answers.
Yeah, ma'am, thank you, ma'am. Thanks a lot. Really, this is an enlightening session for us. Ma'am, these are all, we have a few very basic concepts to know in this topic. So the first one is, can you just explain us about copyright, and what are the products, and what is the field is record it? Because we have patent, copyright, trademark. Can you just differentiate those things, ma'am?
Differentiate with respect to others, as in copyright and other forms of IPRs?
Yes, ma'am. Just what are the things are required trademark? What purpose we need to go for trademark?
Okay.
So what are the articles required for copyright? And in case of the patents, we have sometimes a design pattern, a process pattern, and these are all the things, ma'am. Because we have little idea about it, but we are not in depth at least. Yeah. So we need basic. What is that?
Sure. So let me start with the trademark. So trademark is again used to protect, let's say, various things. So for example, your college name, let's say, if you want to protect your college name so that nobody else can use it, then in that case we have to go for trademark. So if you want to, let's say, protect the logo of your college, I'm just giving a few examples here. So, the logo would be protected by means of trademark, so that similar logo cannot be used by any other college or any other company as well. Okay. So in this particular case, what happens is that, there are 45 classes. Okay. So whenever we have to fill out any application for the trademark, we have to select a specific class in which we want to protect the invention. The product, right? So, for example, in my case, like IP lawyer, since we are legal services providers, so our company name IP lawyer would be protected under class 45, because that class is specifically for legal services. So that means no other company tomorrow can have this name in legal services as IP lawyer. Okay, so this is why trademark is mainly required to protect names, logo, sign and everything. Okay, and for each class we have to file the trademark application. Okay, so let's say if I want to use IP lawyer in other fields, so it's, for example, medical services as well, then in that case I have to reserve this name in medical services as well, in addition to the legal services, medical services as well. Okay, so this is about the trademark. And with respect to the copyright, it is mainly, you can say, is used to protect creativity. Okay, so broadly, generally people go for copyright protection of algorithms, or let's say if you have written any books, then of course that is done by default. And let's say if you have written or done something, let's say you've created a painting and you do not want others to replicate that painting, you go for copyright. So copyright, broadly, you can say that it is used to protect creativity or expression, right? So for example, movies and songs, they are specifically protected by means of copyright. So it is not that, if let's say somebody has written a fiction story, so the other person cannot copy it. So it is just that, the expression of writing the fiction, right? Of course, you can see that a lot of people write fiction stories. It is not that if one has written a fiction, then other cannot do that. Of course, there are movies as well, there are love stories as well. So it is not that if one person has made a movie on love story and another person cannot make it. It is not like that. It is just that because the expression or the it would not be the exact replica, right? It's just that it would be a love story, but it would the dialogues would be different. The way of the content of the story might be different. Not that it's not a love story, but still the content would be different. So on that, you generally go for copyrights, music and everything. Okay. And with the respect to patents and designs, patents, again, all the technologies, if you have anything in so any recommendation for doing anything, it could be related to recommendation for doing in a specific way for agriculture. It could be a recommendation to manage the traffic on the road. So I'm just giving few examples. Any machine that can detect coronavirus. So these are the examples for going for the patents. And the design, as I mentioned, it is just the outer appearance. So it could be a very small thing. So for example, water bottle. It could be any let's say shape of the mouse or pen or anything, or it could be as big as design of a car. So it just protects the outer appearance, not the functionality. So let's say if I am protecting shape of mouse, then in that case I'm just protecting the shape of mouse. I'm not protecting the functionality if it has new functionality as well. So for functionality, we have to go for the patents. I hope I have answered your questions.
Yes, ma'am. Thanks a lot, ma'am. Thank you so much, ma'am.
Thank you.
Ma'am, Dinesh here from Placement Cell. So I have a question with me. I request you to throw more lights on the commercials that is involved when it comes to a brand to get a trademark or a service to get it. Commercials, I wanted to know, ma'am. So what is the commercials involved when it comes to a trademark, a copyright, or a patent?
Okay. So commercial side, let me talk about patents first. So in this particular case, as you might already be aware that not all the patents, so whatever patents that we are filing, it is not that 100% of patents would be granted. Okay. Some percentage would be granted, some percentage would be rejected, and and even not all the patents that we got will be commercialized. Okay, so it actually depends upon lots of factors. So for example, it mainly depends upon the quality of the invention. Okay, and of course the quality of writing the patent application, right? So both of these things are very important, and we have to also consider the fact that the claims, we have claims in the patent application which are actually enforced. Okay, so if the claims are written in a very narrow manner, then in that case the commercial value of the patent will go down, because nobody will take it because it's too narrow. And that is why nobody will see that in future this patent would be a problem, because it is quite narrow. So it is, we have to, that is why whenever we are filing a patent application, we have to make sure that the claim is broad enough so that it has commercial value. Because if the claims are very narrow in nature, all the features are coming in the, let's say, first claim, then we know that any product might not be having this, of course, in this much detail, and that is why nobody will take this patent from us. So that is why first is that the quality of the invention, and of course quality of the writing the patent application should be very good. And we need to take care of all the protocols for this. And after that, for the commercialization purposes, there are various ways in which a patent can be commercialized. First ways is the infringement detection. So in this particular case, like in case of Dr. Michael Doyle, he actually found that Microsoft is using his patent protected technology. So in this case, we can also find that all the products that are launched after our patent is filed. Okay, so first way is to find those companies is this. Secondly is the technology licensing. So in this particular case, we don't have to think that whether a company is using our patent protected technology or not, but we have to see what all companies would be benefited if by using our technology. Okay, so for example, if you are coming up with an invention that can reduce noise of fan in laptop, okay, then you have to see whether this can be used, this invention can be used in uh, maybe ceiling fan, or maybe in reducing the noise of fan in cars. So based on this, you have to reach out to all those industries or all those companies which are dealing in this way, and you can tell the problem that for this kind of problem I have got a solution, I have got a patent on this. So, and based on that, they will go for commercialization and everything. So this is about patents. So for trademark, it is for commercialization, it is trademark. I would say it is generally to protect our own brand. So it is, trademark is very, very important because it is all the things are associated with the trademark only. So for example, uh, so let's say Coca-Cola, right? So they have got trademark. So in order to manufacture or sell Coca-Cola, you of course need legal permission from them, or you can say franchisee from them. And the bigger the company, the bigger would be the amount for getting the franchisee for this. And that is why the trademark and everything comes into picture, because you create a hype of your product using your trademark. So just to use the trademark, you have to pay a lot of money, right? So this is how the commercialization of trademark will come into picture. I hope I have answered your question, sir.
Yes, ma'am. Thank you so much.
Thank you so much, ma'am. Thank you so much, everyone.